So we will now proceed to questions under the 5-minute rule. I yield myself 5 minutes for the purpose of questioning the witnesses. Professor Feldman, would you respond to Professor Turley's comments about bribery, especially about the relevance of the elements of criminal bribery?
Yes. Bribery had a clear meaning to the framers. It was when the president, using the power of his office, solicits or receives something of personal value from someone affected by his official powers. And I want to be very clear. The Constitution is law. The Constitution is the supreme law of the land. So, of course, Professor Turley is right. You wouldn't want to impeach someone who didn't violate the law. But the Constitution, the supreme law of the land, specifies bribery as a ground of impeachment, as it specifies other high crimes and misdemeanors. Bribery had a clear meaning. If the House believes that the president solicited something of value in the form of investigations or an announcement of investigations, and that he did so corruptly for personal gain, then that would constitute bribery under the meaning of the Constitution, and it would not be lawless. It would be bribery under the law.
So the Supreme Court case in McDonnell interpreting the federal bribery statute and other decisions interpreting the statutes would not be relevant.
The Constitution is the supreme law, and the Constitution specifies what bribery means. Federal statutes can't trump the Constitution. They can't defeat what's in the Constitution.
Thank you. Professor Gerhardt, would you respond to Professor Turley's comments about obstruction of justice or obstruction of Congress, please?
Yes. On obstruction of justice, one thing I want to emphasize is obstruction of justice is not just about obstruction of a court. It's obstruction of any lawful proceeding. And so that obstruction isn't limited to whatever is happening on the courts. And obviously here, there are judicial proceedings going on, but there's also a really critical congressional proceeding, which brings us to obstruction of Congress. And with obstruction of Congress, I don't think, in fact, I can say, I know there's never been anything like the president's refusal to comply with subpoenas from this body. These are lawful subpoenas. These have the force of law to them. These are the things that every other president has complied with and actually acted in alignment with, except for President Nixon in a small but significant set of materials.
Professor Turley implied that as long as the president asserts a fanciful, ultimately non-existent privilege like absolute immunity, he can't be charged with obstruction of Congress because, after all, it hasn't gone through the courts yet. Would you comment on that? Professor Gerhardt?
I'm sorry. I missed part of the question. Please, I'm sorry.
Professor Turley implied that we can't charge the president with obstruction of Congress for refusing all subpoenas as long as he has any fanciful claim until the courts reject those fanciful claims.
I have to respectfully disagree. No, his refusal to comply with those subpoenas is an independent event. It's apart from the courts. It's a direct assault on the legitimacy of this inquiry, which is crucial to the exercise of this power.
Thank you. Professor Carlin, I'll give you a chance to respond, if you would like, as well as the same question.
I wanted to respond to the first question about bribery, if I could instead, which is, although counsel for the minority read Samuel Johnson's definitions of high and crime and misdemeanor, he didn't read the definition of bribery. Now, I have the 1792 version of Johnson's dictionary. I don't have the initial one. And there he defines bribery as the crime of giving or taking rewards for bad practices. And so if you think it's a bad practice to deny military appropriations to an ally that have been given to him, if you think it's a bad practice not to hold a meeting to buck up the legitimacy of a government that's on the front line, and you do that in return for the reward of getting help with your reelection, that's Samuel Johnson's definition of bribery.
Thank you. And Professor Feldman, if Washington were here today, if he were joined by Madison and Hamilton and other framers, what do you believe they would say if presented with the evidence before us about President Trump's conduct?
I believe the framers would identify President Trump's conduct as exactly the kind of abuse of office, high crime and misdemeanor that they were worried about, and they would want the House of Representatives to take appropriate action and to impeach.
And they would find obstruction of justice, obstruction of Congress, and abuse of power, or some of them?
I believe that if the evidence supported those things in their minds, and if Congress determines that that is what the evidence means, then they would believe strongly that that's what Congress ought to do.
Thank you. I'll yield back my time, the balance of my time. I'll now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for 5 minutes for questioning the witnesses.
This just keeps getting more amazing. I think we just put in the jury pool the Founding Fathers and said, what would they think? I don't think we have any idea what they would think, in all due respect, with this, because of the different times, the different things we've talked about. But also to in some way insinuate on a live mic with a lot of people listening that the Founding Fathers would have found President Trump guilty is just simply malpractice with these facts before us. That is just simply pandering to a camera. That is simply just not right. I mean, this is amazing. We can disagree. What's amazing on this committee is we don't even disagree on the facts. We cannot even find a fact right now where it is not going through the public testimony and also even the transcripts and all. That is not. Mr. Charlie, are we going to deputize somebody between now and the founders into the jury pool here?
Well, first of all, only I will speak for James Madison. Yeah. No, we all will speak for James Madison with about the same level of accuracy. It's a form of necromancy that academics do all the time, and that's what we get paid for. But I just want to note a couple of things. First of all, I do find it rather surprising that you would have George Washington in this jury pool. I would strike him for cause. George Washington was the first guy to raise extreme executive privilege claims. He had a rather robust view of what a president could say. If you were going to make a case to George Washington that you could impeach over a conversation he had with another head of state, I expect his powdered hair would catch on fire. Also, I just want to know one other thing. And I am impressed with carrying an 18th century copy of Samuel Johnson with you.
It's just the online version.
It's just the online version. You, as an academic, I was pretty darn impressed. I just want to note one thing which may explain part of our difference. The statutes today on bravery are written broadly, just like they were back then. That was my point. The meaning of those words are subject to interpretation. They're written broadly because they don't want them to be too narrow. That was the case in the 18th century as they are today. But the idea that bad practices could be the definition of bribery, really? I mean, is that what you get from the Constitutional Convention, that bad practices? Is that why Mason wanted to put in maladministration? Because bad practices is not broad enough? This is where I disagree. Now, the other thing that I just wanted to